Does poor man's copyright actually work? No, it doesn't. There is no provision in copyright law for mailing your work to yourself, and no court has ever relied on a self-mailed envelope to decide a case. Not one. Here's what most songwriters miss. Your copyright already exists, automatically, the moment you record your song. The envelope was never the protection. What you actually need is proof. Over the next 6 minutes, I'll cover 4 things: what poor man's copyright actually is, why the envelope fails every test, what the US Copyright Office says about it, word for word, and what genuinely protects your song, including a fee deadline coming this fall. First, what is poor man's copyright? It's the practice of mailing a copy of your own song to yourself in a sealed envelope and keeping it unopened. The theory is that the postmark proves the date you created the work. The idea has circulated in musician circles for decades. It sounds practical. It costs a stamp. If someone ever claims they wrote your song first, you open the envelope in front of a judge and the postmark settles everything. That's the pitch, anyway. Here's the reality. A self-mailed envelope is a receipt you wrote to yourself. No neutral third party verified anything, and the person who benefits is the same person who sealed it. It's worse than doing nothing because it creates a false sense of security that keeps you from taking real protective action. So why does the envelope fail every test? Because every link in the chain is broken. Start with the postmark. It proves when an envelope was mailed, not when the song inside was created. Write a song in 2015, mail it in 2025, and the postmark says 2025. It's a shipping record, not a creation record. Second, envelopes can be steamed open, resealed, or mailed unsealed in the first place. You could mail yourself an unsealed envelope today, slip a song inside years from now, and seal it then. The Postal Service certifies delivery. Third, the legal standing, there is none. No U.S. court has ever relied on a self-mailed envelope as proof of authorship. As evidence, it's worthless. A self-serving document with no chain of custody, no tamper evidence seal, and no independent verification of anything. Finally, nothing binds the postmark to the contents. The date exists on the outside, the song exists on the inside, and no technical mechanism links them in any verifiable way. Each of these failures is independent. Fix one, and the others still sink you. Now, what does Copyright Gov actually say? The U.S. Copyright Office addresses this practice by name in its official FAQ, and the language is worth hearing exactly as written. The practice of sending a copy of your own work to yourself is sometimes called a poor man's copyright. There is no provision in the copyright law regarding any such type of protection, and it is not a substitute for registration. Sit with that for a second. No provision in the law. Not a substitute for registration. The federal agency that administers copyright law examined this exact practice and said in writing that the law doesn't support it. This isn't a gray area. It's the official word. So what actually protects your song? 3 layers. Layer 1, automatic copyright. And here's the good news. You already own it. Under Section 102 of the Copyright Act, protection exists the moment your work is fixed in a tangible medium. Record the vocal, save the file, write down the lyrics. Your copyright exists. Nobody has to grant it. But owning a copyright and proving you own it are 2 different things. That's the gap the envelope pretended to fill. Layer 2 is time-stamped evidence. SongSecure generates a SHA-256 hash of your file, a unique digital fingerprint, and anchors it to the Solana blockchain. Change a single byte of that file and the hash changes completely. The result is an immutable, independently verifiable record that your exact file existed at a specific moment. Verified within minutes, not months. And your song stays private. Only the fingerprint goes on the blockchain, never the file itself. The pricing is built for working musicians. You start with a free 7-day trial. After that, it's $9.95 a month, or $97 a year. And that covers unlimited works. Every song, beat, and lyric sheet in your catalog gets time-stamped proof, not just the singles you think will hit. And when you share work, beats to artists, stems to mixers, SongSecure, SongSecure's verified delivery system, documents exactly who received your file and when. That matters, because infringement claims require proof of access, and access is where most cases collapse. In Cell vs. Gibb, the claim failed because access couldn't be proven. Layer 3. Federal registration for your commercially significant releases. Registering with the Copyright Office costs $45 to $65 per application and takes about 4 months to process. But register before infringement, or within 3 months of publication, and you unlock statutory damages and attorney's fees. Remedies no private tool can provide. One heads up. Those fees are going up in fall 2026. The single application rises from $45 to $55, and the standard application jumps from $65 to $85. If you have a release-ready song worth registering, doing it sooner is simply cheaper than doing it later. Put the 3 options side by side. The envelope costs a stamp, proves nothing, no legal standing. Federal registration, $45 to $65 per work, about 4 months, powerful statutory remedies. SongSecure, $97 a year, unlimited works, verified within minutes. 2 of these belong in your strategy, 1 belongs in the trash. So, the playbook is simple. The day you finish a song, upload it to SongSecure and timestamp it. Use SongSecure whenever you share it. Register your commercial releases federally before the fee increase. And never mail an envelope to yourself again. There's more to this story. The full comparison table, the evidence rules, and the case law on access. It's all in the complete article at SongSecure.com. The link is in the description. Your songs are assets. Protect them with proof that actually holds up.